Good morning, Neha madam.
Good morning, sir. How are you?
I am fine. How are you, ma'am?
Yes, I am great. Thank you, sir.
Within 10 to 15 minutes, we are going to start
All
because the
right.
time is 11 a.m. Our student will take 2 or 3 minutes to join.
Right. Yes,
Right?
yes, yes,
But
sir.
we start, right?
Sure, sir. No
Okay. Thank you,
issues.
ma'am, for joining.
Yeah,
And
thank you,
very
sir.
soon we are going to start. Okay.
Sure, sir. Sure.
Okay. Thank you.
Good morning, all. Yatin sir, just acknowledge, please. Am I audible?
Yes, sir, you are audible.
So, can we start now? The students will keep
Sure.
on joining gradually, right?
Sure, sir. We can start, sir.
Right, sir. Well, very good morning to you all, and a special morning to the guest of the day, Miss Neha Goyal, and our Dean R&D, Dr. Anuranjan Misra, my dear faculty members and students. In fact, the society talks about the property, and the property mean the property that we understand is the flat, the building, the land, or I mean anything related to this. Of course, being the intellectuals, we need to have some other kinds of properties as well. And in fact, today is the day when we are going to talk on various such aspects where being an intellectual, you can have the intellectual properties as well, and how to preserve your intellectual properties and how to hold them. So we have the guest today, and she is going to talk on these things much. And of course, it is one of the series of events in the under the innovation institutions innovation council of GNIOT. And of course, it is jointly organized by the MSME, this incubation center MSME at GNIOT, and Computer Society of India Ghaziabad chapter. So I welcome you all to this event, and expect that you will definitely going to get various benefits out of the today's session. With this, I would like to invite our Dean Research and Development, Dr. Anuranjan Misra, to give the welcome address for the event. Sir.
Thank you, Tiwari, sir. Good morning, all. So, if we are talking about the intellectual property rights, so the intellectual property rights are the rights given to the person over the creation of their minds. They are usually give the creator an exclusive right over to the to use his or her creation of certain period of time. So definitely, if anyone has developed something, that in this world, if we think about what we can give in this world, so the answer is only time. What we can give in this world, we can give our time only. Rest over is already available in this beautiful world, so we can give the time only, right? So on that time, what we can do to the creation of mind, definitely it is needed, and so it is registered somewhere, it is must be acknowledged somewhere. So that's why the intellectual property rights are there. And there are basically four types of the intellectual property rights. They are the trade secrets. It means the secrets of the company. The company has some secrets, such as the Coca-Cola has their own secrets, how they make this particular drink. And the second one is the patent. Patent is for the if someone has done some innovation, some product or some process, that can be registered as a patent. And the patent, they can give the patent, they can sell to the patent to the others for the use, and they get some money for that, and some year this is assigned for some years. And the copyrights, as we know, copyrights, our research papers, books, these are the for the copyrights. And the trademarks, various marks, they are the trademarks. So definitely, madam is uh, Neha Goyal, madam is with us, and she is a director patent in UniPatrde consultant LLP, Noida, UP. So I think she will told much about it. This is according to my best knowledge. So thank you all.
Thank you, sir. Before I hand over the session to Ms. Neha, I would like to, briefly discuss her profile that will motivate in the students as well as the faculty members to listen her and get the benefit out of it. Ms. Neha Goyal is an IPR practitioner having a total working experience of 14 years in intellectual property rights, especially patents. She is a gold medalist in bioinformatics from Punjab University, Chandigarh, and served 3 years as lecturer in a couple of reputed colleges. Thereafter, she moved to the couple of international IPR firms. She has extensive hands-on experience in handling patent analytics, patent drafting, patent filing, patent prosecution, trademark, design, and copyright related portfolios. She has worked for prestigious clients like Boston Scientific, Unilever, GSK, Top Globe, Tel Aviv University, uh, Uflex Limited, and many new startups. She understands the IPR law of India, Europe, UK, US, Australia, and Canada. Currently, she is the founder of UniPatrde Consultants LLP and heading a team of around 10 to 12 technical and legal professionals. So I welcome once again Ms. Neha Goyal to the event. Please join and enlighten the students as well as faculty members with your experience.
Thank you, sir. Thank you. First of all, I would like to thank you, GNIOT and the faculty and all the members, students, for giving us the opportunity to share my learnings with all of you. And so we can start. I hope you are able to view my screen.
Yes, we can just run the presentation. It is still in minimized
Yes.
mode.
Okay. Now
Yes, it is. It is
yes.
fine now.
Okay. So intellectual property rights, just briefly defined and explained by Dr. Tiwari and Dr. Mishra also. So it actually got recognition in our country, especially when our honorable Prime Minister Mr. Modi, he brought up the startup policy. But we Indians actually took time to understand this startup policy and intellectual property rights, and actually it was well accepted, especially during this lockdown time, that people really got motivated to invent and to understand IPR, to file patents, trademarks, and we actually received many queries regarding and requests regarding the filings, the inventions during this period of lockdown. So and it got so much accepted that it has been now a part of almost all the different domains, technical domains of the academics. And even some students, especially engineering students, they want to make career in IPR. Some students, they just want to study because it's part of the curriculum. Some students, even the faculty, they want to be inventor. They are now getting the good recognition for their research work, so they want to file it in through the patents. But majority of us still have many myths, and they have some question marks that what is actually this IPR, intellectual property rights, which seem to be very difficult words for some of the students. So I would like to cover answers to all of such curiosities in this session. So let's try to be make this session interactive by having conversation and discussion from both the sides, rather than just me only speaking and sharing my experiences with you. So first of all, I'll just start with basic thing, intellectual property rights. So let's just break it. Intellectual plus property plus rights. Now property, just like just Dr. Tiwari said, that property we understand, it's a physical property. For example, you purchase a piece of a land or a flat. Just coming to exciting examples of students, suppose you purchased a bike. Now, whenever you purchase a bike, you will often register it on your name. You will get some registration number. You will put that registration number on your bike. So you are going to some, official place where you are getting it registered. Why you are getting it registered? So that someone else does not steal your property and claim it as it his or her owns. So that's why you try to protect your bike, newly purchased bike. So similarly, intellectual means an idea. So anything which we think of, any solution to any existing problem. Suppose a scientist or an inventor, they come up with a solution to a particular problem, and that particular problem is being solved by that unique solution. Now, do you really want that if that scientist should allow the other people to copy that invention or that idea? Just, because that's research, and would you really accept it that hard work and the investment which is being gone into providing that solution, it should be, copied easily by the others? So similarly, just like you are protecting your bike, that it should not be infringed or stolen by someone else who can further commercialize it. So similarly, we can also claim our intellectual. Now this is also a property. So that's why through intellectual properties, we basically try to protect our intellectual, our ideas, our mind property through IPR. So basically there are 4 types of IPRs which are generally considered: patents, trademark, copyright, trade secret. Now in patents, further we have 3 types of patents: utility, design, plant. We will just discuss, each of the types in more details. Now you must be wondering that I have, given blue color to all the boxes, but why this yellow orange color to trade secret? Why I'm giving this different color? Because trade secret, though it's a type of IPR, but it is actually in India, it's you just cannot claim the trade secret. Now in patent, you have an idea. So whenever you think of an idea, you can protect it through patent. Anything name of a product, you can protect through trademark. Anything, content, you can protect through copyright. But what is a trade secret? So it's a secret formula which is about your business. And in India, there is no jurisdiction to which you can go and say that, okay, this is my trade, this was my trade secret, and somebody has, stolen it or infringed it. Apart from these 4 basic, IPRs, there is also additional IPR, which is geographical indication. Now, geographical means area, indication which is depicting a particular area about a certain product. So I'm just going one by one in detail. Now, patent. So patent is actually a negative monopoly right. For example, any problem which comes into your mind that, okay, in our daily life, we just wake up and we have a certain routine and a schedule. During the schedule, we come across so many problems. So we, then think of a solution. For example, like in the lockdown, people were just, they were struggling for the oxygen cylinders. Now, so many inventions came up that how actually we can have an arrangement in which we can have portable oxygen cylinders, or how we can absorb, oxygen from the atmosphere without going to the hospitals. So this is a solution to a particular problem. So you can protect that particular solution, that idea, which you can say intangible idea, which cannot be touched. So that idea, you can protect it through patent rights. And to get protection through patent rights, you actually really need not to have an idea in tangible form. I mean to say that suppose you have thought upon idea, but you do not have funds to make a prototype. So it's very, very important to secure that idea so that the other person does not copy it. So you just go to the Patent Office of India, you just register and you get a date. For example, today is 28th of July. You protect your this idea that you have made, you have come up with a device of absorbing oxygen from the atmosphere. Now you have got that particular date. So if anybody comes after this particular date and claims that he has actually worked upon this invention or he has similar idea of yours, but you will be given the priority because you have registered your idea first. And how you can get protection, that is through patent. So getting this protection, and you for this protection also there is something which is to be given to the government. You know that nothing is there for free. So it's a contract between the government. So government says that, okay, you can register your idea with us. We will give you the date. We will give you the security. But you have to disclose the entire process or the device to us. So this will be a contract for 20 years. And what the government will give you? The government will give you a right. It will grant you a right to its owner to exclude others. Now, it's very, very important that you, through this patent protection, you will stop others from making, selling, or using your invention for a limited period of time. And what is this limited period of time? 20 years. Now the question arises that why they have limited the period. Of course, anybody who has invented something, so he should have, right forever. Now, why it's limited period of time? Because otherwise there will not be improvement in the inventions. The person will, of course, you know that we humans work only whenever there is a stress or there is some deadline for us. So when there will be a deadline of 20 years, so automatically the inventor will think for something improvement so that he can improve his product and he can come up with better solution. So that's why, this is for a limited period of time. And in exchange of this, government asks for publishing then enabling public disclosure. Yes, you have to disclose your entire invention to the public. And why we are saying it a negative monopoly right? Negative monopoly right means monopoly that you are enjoying your right, but it doesn't mean that you are the owner of this is forever. So it is a right which is given to us, but it is to exclude others, to stop others from commercializing your invention without your permission. So patent is a territorial right. Now, territorial rights means if you want to get the protection for your invention or a product in India, then you have to file patent application in India only. And if you want to file in US, then you have to file separately in US. And it has a limited period of time of 20 years, which we have already discussed. Now, whenever it's not that easy to get the patent application, patent rights. So whenever you go to the patent office, of course, there will be a certain criteria set up, that actually decide that whether your invention should be granted patent or not. Now, the first criteria is the novelty. That is, your invention should be absolutely new. Of course, if the invention is already registered in the form of patent, or it is, filed by some other inventor worldwide, so then you will not be granted the patent because you are already, this invention is already known. So it has to be absolutely novel. Now here I just want to emphasize one very, very important point is that often, inventors, they have confusion in their mind that this novelty, how do they come to know that if this particular invention is already known? There are some databases, search databases in which, patent office, they conduct the search. Now this search is conducted, which is very, very important point, is it is conducted worldwide. But for territorial rights, you will be granted patent rights in India only, but the search for this novelty will be done, it will be conducted worldwide. Entire world search will be conducted. Second is inventive step. Now, of course, you will come up with a question that it's not possible to invent every time something absolutely new. So what to be done if the invention is already known and we have come with some improvements? Then of course you can get patent rights on that also. But for that, your invention or your product or your process, it has to be inventive. Means that there should be some technical improvements and there should be some economically benefits. For example, you have come up with this, again we'll take the same example, oxygen absorbing devices there from the atmosphere. You have reduced the features and you have reduced the features that much that actually the cost of the device is now half, and people are able to use that particular device in a more comfortable manner. So of course this will have inventive step. Since the cost is reduced, the features have also been there, been some improvements, the previous problems have also been solved, so it will be supported by this inventive step. Now next, which is very, very important, is industrial applicability. Now your invention, it should not be something like that, oh, you have come up with a mathematical formula and you say that this is the formula and can I protect it? The invention should be able to be mass produced in industry. Means you are able to, equation cannot be produced in a factory or an industry, right? So that's why, industrial applicability factor is very, very important. Like to the computer science, people often ask us that if algorithms can be, granted patent rights. Algorithms per se, if you say that set of instructions which are given in the algorithm, no, you cannot get patent rights on it. But of course, you can get patent rights on a method which is being implied by that algorithm to solve a particular problem. For example, I come up with a washing machine. I made a software, an algorithm which has improved efficiency of a washing machine. So now this washing machine is being able to be produced in an industry. So definitely we can do it. Another example, like bootstrapping, is very much famous these days. Blockchain. Now blockchain method, again, now this methodology, this technology is being used for various applications. So as such, per se, on blockchain, you will not be able to get the patent rights. But yes, on the methodology which is being implicated in the technology for the particular application, then of course you can get the patent rights. There is no age bar, it's not like that a particular age limit is there. Anybody can invent and they can seek the patent protection. Very interesting example I would give you of my own son. He was just 5 years old and we filed a patent for his invention. So even in US, the youngest child was 9 years. That girl, she came up with the brilliant solution to a problem which her dog was suffering from. So there is no age bar. Anybody can invent at any age, at any period of their lifetime. And any problem, there is nothing restricted like that. Okay, only the software can be protected or only electronics or any mechanical, any problem, it can be solved. If it can be solved through novelty, inventive step and industrial applicability, and if these three criteria are being covered, then of course the patent rights can be granted. This is the certificate which you get after your patent rights are being granted. And to get the patent rights, it involves many steps, which we will just discuss in forthcoming slides. And it takes almost 1 to 3 years to get patent rights. There is no hard fast rule that you have to be like super, some ideas should be there, or some very big solution you have just come up to solve a very big problem. It can be anything, any funny problem even. One of the funny patents I just got, it's anti-eating face mask. Like these days we are covering our mask to get protection from coronavirus, but this was in 1982 this mask was there, which was being used by a person to block his mouth so that he does not eat much. So it is to get weight reduced. So this is an anti-eating face mask. Now this is a greenhouse helmet. This is so funny example. It's there, like this person is wearing the helmet and he's having the plants so that he can get breathe in oxygen, which is given by the plants at just a short distance. So this is quite a funny patent, and it is of 1986. So there is nothing bar to any problem. Anybody can think for any type of problem. Any funny problem can also be there. So let's going to further dig down to the patent, different types of patents. The first one is utility. Utility means when you are protecting your idea, solution to a particular problem, and its life term is 20 years from the date of filing the patent application. Design means that you are protecting aesthetic view, appearance of a product. For example, a mug, how does it looking like? So you can just protect that outer appearance of a product, and its life term is 10 years from the date of filing the patent application. You can also protect your plant varieties, like farmers, they come up with a unique variety which has suppose enhanced the breeding and population of a particular grain. So then of course you can protect that variety through plant protection, and depending upon the different plant varieties there is a different life term, like 5, 10, 15, depending upon the plant varieties. Trademark. Now trademark, well, it's a mark which actually relates to your trade. So any mark or sign which relates to your trade is actually defining the trademark. Now it can be symbol, word, letter, sign, logo, anything, like GSK, Bayer, Johnson & Johnson, Apple, so Microsoft. So all these are what they are recognizing the brand value of a particular company. And again, to get a trademark, there are certain norms, certain conditions and criteria which are there, which is being followed by the trademark office. So if you are falling into that criteria, so then only you will be given the rights of trademark. And trademark, you might have seen, like TM, for example in UniPatrde we have like this TM. So it means that you have protected your we have registered this word mark at trademark office. Sometimes it's written R by circular circle. So it means it has been registered, they have got the registration. So after filing your trademark, you can use TM, and our trademark is also being accepted. So in September we will get the registration letter also. Next is copyright. Now copyright, it protects artistic work, like painting, any sculpture, any drawing, any photograph, architecture work, anything which is being written on the website, any literary work, computer programs, tables, algorithms, databases, anything, you can protect it through copyright. Actually, by default, anything content, like suppose I am presenting this presentation, this is my original content. So this is automatically copyright. So I can write like this, see copyright 2021. Suppose you present something on YouTube and then again it's copyright. But then question arises, why do you need to protect copyright? Now copyright, suppose somebody copies this presentation and they use it, start commercializing, they start charging people, by giving this presentation. So of course, this I will not like it and I will go to the Copyright Office. Now Copyright Office will say, the High Court, sorry, not Copyright Office. In Copyright Office, you will simply file your application. To the High Court, I will go and they will say, okay, Neha, you just show us a proof that this is your copyright. So by just showing this presentation, this will not be my proof. So I have to get it copyright registered. If I have that date and I have that certificate, so then only the court will believe that, okay, so she is the, you have this proof. Otherwise, I am the owner of this property, but I will have to have a proper proof to show that I am the actual owner of this presentation. And for copyright, it should be 60 years from the year following the date of publication. Now comes a trade secret. So it's a secret of your business. Just like Sir gave us the example in the starting, like Coca-Cola. Now Coca-Cola, the formula of that Coca-Cola, they have not protected it through patent, because now you understand that to get the patent rights, you have to disclose your entire information to the public. Public will copy it, they can try making it. Trademark, it will not come under trademark. Then copyright, again the copyright. So what the people do, just like, like ladies, they keep their jewelry safe in the lockers. Similarly, the owners, they keep their secret. Suppose in Coca-Cola case, formula of making that Coca-Cola protected in one safe, and they do all the different ways to protect it. In case anyhow, if that secret gets leaked or it is copied or stolen by any of their employees or somebody outsider, so then they cannot go to the court to fight for this claim. In India, especially in foreign countries, there are some provisions for trade secrets, but India, it's not. Now, geographical indications. So it is a sign which is being used on products corresponding to a specific geographical origin. Now, for example, basmati rice. Now, it's very famous rice, Basmati, we just always go to the shop and we say, no, we want high quality rice, which is like basmati. And basmati rice is confined from a particular area of India. It is also found in Pakistan. Now, Pakistan has got their basmati, protected. So it is actually making difficult for India to get that basmati registered in the foreign countries. So it's very, very important to protect your property, as early as possible, so that other people, they just don't copy it. I just want to check with the students, especially if they are sleeping during this session. Can anybody help me to know if what is this, why I'm showing this example? What is it famous for? Yeah. Anybody from the students? Sir, can students unmute themselves and contribute?
No, especially we'll have to.
Okay, all right. So, okay,
There is a hand raise, and if you wish, I can just check with
yes,
the
so
student.
yes.
Ankit, if you are there, I am just opening your mic. Please ask your query. Ankit, just unmute yourself and ask what you want to inquire. Ankit Kumar. I don't know whether it was a genuine hand raise or it was accidentally done.
Okay,
So
I was expecting answer for this. First
is
person.
it Solapuri sleepers or something?
Sir, I'll correct you. It's Kolhapuri. It's not
Oh, I'm
Solapuri.
sorry. It's a
Yes,
Kolhapuri. Right.
it's
Good.
Kolhapuri chappal, and it's
Right.
very much famous. So we have got protection on this. And for geographical indications, only the tribal, a group of people or a trust or an organization, they can protect it. Not the individual person, they can protect their property rights through geographical indications. So similarly, Darjeeling, this is a tea which is very famous from Assam. And anybody, he or she can help me for this third example. It's a very famous tradition. Okay, so it's a fulkari, which is very much famous in Punjab, Rajasthan, and Haryana also. So these are the some properties, and there are many such properties in India which are being registered and protected through geographical indications. Now coming back again to patent. So what is the actually process and various steps which are involved in protecting or filing the entire procedure? Now the first procedure is the identification of novelty. Like we discussed, that novelty is the first criteria. And this first criteria is to check whether your idea is already known or not. Now here I just would give you a very interesting example. In 1964 in Kuwait, there was a freighter, a ship. It was carrying 5,000 sheep, and this ship actually got overturned. It capsized on Kuwait dock. So at the harbor, it just got overturned, and all the sheep, majority of the sheep, they just got sunken in the water, and this water was actually a drinking supply to Kuwait. So now the sheep, the dead bodies of the sheep were in the water, and it was a really worry to the Kuwait government and people that it is actually contaminating the drinking water supply, and there should be something done so that they can remove this ship and the dead bodies of sheep. But they were not able to come with a solution, so they thought of a crane, but it uh, would be taking long time, so they just ignored that idea. And then there was a Dutch inventor, Carl Creuer. He came up with a solution that let's fill up this ship with buoyant, buoyant, you understand, which can float on water, with a tube. So they started filling up this ship, with 27 million of polystyrene foam balls. So what happened? The ship, it just rose, and they could remove that rosen ship through the crane or through airlifting. So this is how that inventor could actually solve the problem. And this inventor, he filed a patent application in Germany. And so what you think, that should he get the patent right or not? Did he get it? Anything? I would like to, like students, especially if they can just join in this discussion. Do you think it was really a great idea and he should have given the patent rights? Anybody from the students? I hope you all have understood that what was the problem. The problem was that the ship, it was carrying sheep, bakri, and it got actually sunken, the ship, it got overturned and the water was getting contaminated with ship and dead bodies of sheep. So we had to remove the ship. So what did they do is they filled the ship with these buoyant balls, these lightweight polystyrene, thermocol ki jo balls hoti hai na, so they just started filling this ship with these balls, and so that the ship, it actually came up the level of the water and it was removed through airlifting. And you will be surprised to know that when this patent application was being examined, the examiner who was supposed to examine the patent application, he came his home and he found that his daughter was reading a comic on Donald Duck, and he got this idea published in this comic. In the sunken yacht. So this was a story, this was a comic in which they actually showed this idea, the same invention was there. And you know, to the surprise, the inventor was not granted patent rights. So it's very, very important to conduct the search, because you are investing. When you will be filing the patent application in the patent office, you will be paying some fees, you will be paying fees to the patent agent, you will be investing so much in trademark, copyright, design. So it's very, very important to clear the at least the first step. So if you are an inventor and you don't have the licensed databases, you can search it for free through Google Patent also. So Google Patent, it provides a database of the patents worldwide, and it has now covered maximum coverage of the patents worldwide. And through that, you can just run few search strings. Being computer engineers, you know how to conduct a search, and you can find out the if there is something idea like that. But of course, for professional search, like more in-depth search, you can take help of the patent agents as well. So after identification of novelty, then we prepare your patent application. Just like you prepare various documents for registering your bike, similarly we prepare the patent application in which we disclose technically and legally about your invention. And then we proceed to file with the patent office. There are 4 patent offices in India. So you can file there as per your jurisdiction. I'm not going to that much detail. Then your application will get published. Published just like your research papers published in the journal. That this publication is similar to that publication, but objective of this publication is different. And it's not that hard. There is a difference, you know. This is very, very important point, because students, faculty, because from the academics point of view, they always understand and picturize that getting the patent application published is just like we are getting the research paper published. Now, for your research paper to get published, it undergoes various examination procedures. They just check how novel is your research data and all that, language, so many factors are there. But for the patent application, your application is being published. It means it is brought to the public, so that if anybody wants to oppose this invention, they can oppose it. For example, there were 2 students, A and B. A and B both were working on an invention. Now, A was a very smart. He just went and filed a patent application. B was not aware of. And B just came to know later on through the publication that, okay, A filed the invention, but he did not give any credit to B. So he will oppose that application. And there will be different procedure for that. So this is the main purpose of publication. And then your application will get examined. So for examination, you have to file again the request for the examination. Then only your application will be examined. Now, examination here for those 3 points: novelty, inventive step, and industrial applicability. And if there are any objections and all the objections are overcome, you will be granted the patent rights. Else, If the patent office rejects it and you don't agree with that decision, you can go to High Court and you can appeal there. Trademark also follow the similar process. Similar steps are there, conducting search, filing, but there is a difference. It will get examined primarily, then it will be published, just like your research papers. So firstly, it will get examined, then it will get published in journal, and else you can prosecute in similar manner to that of the patent. Now here, to my earlier questions, none of you answered, but now I would like to check whoever has understood, whatever the points I gave. Suppose you come up with this phone and now you want to have your startup manufacturing this phone and you want to protect this phone through IPR. So now you have to help me to understand that how you can protect, through which IPR you will protect this phone. So I would like to, sir, if it would be great if you can please unmute students, because this is a good exercise for them and to basically be part of this discussion. Is it possible, sir?
Yatin sir. Ma'am is asking to unmute the students so that they can participate directly.
Sir, from my side, all students are unmuted.
Okay. So anybody who can answer how you can protect this mobile phone? Suppose you have come up with a new phone and you think that you will start your own startup or a company. How you will protect this phone through IPR?
Anyone from the students?
Protected by patent type of IPR.
Okay, can you please help us to know which IPRs?
And suppose I'm going to implement a new feature in my phone, then I have to take a patent of that feature.
Okay. Only through patents we will protect this phone. Just think this invention is yours and you have come up with a new phone which has new features. There are many things. It's a latest phone and you want to manufacture it, you want to start your own business. So how you will protect it?
I have a trademark for it also.
Yes, very good. Patent, trademark.
And
Is
copyright?
copyright? How you will do through copyright?
Ma'am, written information about feature.
Very good. Yes. So, what is your name?
Ma'am, Ritik Jain.
Okay, I think Ritik has understood. So rest of the students, they were sleeping or they have not understood, or I was going very fast. So anyways, thank you, Ritik. There is one more IPR, so we'll just discuss. So through patent, you can protect through two things. In the form of a product, that features you can protect, and the process, the method. So you can protect through patent features, your operating system, any data processing method. If you have come up with some method which is actually able to process the data in an efficient manner, which the earlier methods were not able to, so you can protect that also through patent. So it's a very big myth that softwares in India में तो software को मिलता ही नहीं वो it is a now story long time back, but now Indian Patent Office, they are accepting, but the if point is that it should not be algorithm per se, software per se. It should not be that. You can also protect through patent user interface of the operations of the phone. Now through trademark, like Ritik said, well said, you can also protect through trademark. Now through trademark, you can protect name of the manufacturer. For example, this is Redmi phone. You can protect name of the product. You can also protect a tone. Like, Nokia, you know that this is a famous tone, this is of Nokia, or so many brands are there. So you can protect that, tone also through trademark. Now design. Now how design is, you can protect the outer overall appearance, how your phone is looking. So you can protect all the views, front, back, left, right, perspective views of your phone. You can also protect arrangements and shape of the buttons, how you are providing the buttons if it's a button phone. You can also protect position or shape of the display also. Okay, so you can protect it through design also. Now copyright, you can protect your software, your algorithm, your user manual, software manual is there. Any ringtone you can protect through copyright also. Any startup tones, any images or any website content you can protect through copyright. So any product, whether it is from software, whether it is from mechanical, electronics, any field, any problem, you can protect all through all types of IPR, patent, trademark, design, and copyright. Now, trade secret, it does not come under that you need to go to the office, that you have to keep it secret. It's your wish. Then for GI, that also you cannot do it individually. You have to have a group or a tribal people, and you are either through an organization or through a trust, you can protect it. So basic, there are 4 types of IPRs through which you can protect your product. So for example, being a student as an inventor, if you come up with an idea, so now you know that how you can basically protect your product. Now there are some myths and facts. The first myth is I need a prototype to file a patent and I do not have funds. Now, if you don't know, it's a myth. If you don't have a prototype, you can still file your patent application. You need not to disclose all the details. That is known as a provisional patent application. And within 12 months from the date of filing of the provisional application, then you can file the complete application. For filing the complete application, there is no official fee. You have to pay fee one time only. So to file a patent, if idea comes into your mind, immediately file a provisional patent application. Okay. Second myth is I will disclose my work after getting publication in a good journal. It's not like that. Once your work is being disclosed anywhere, you will not get the patent, because absolute novelty is what is there as per the India patent law. I will look for investors or buyers first, then only I will think for filing the patent application. Now to file a provisional patent application, I should tell you the fees is only 1600 rupees for a startup and an individual. So it's hardly investment, and you can always look for investors or buyers, but after filing your patent application, because there is a chance, and there have been many cases where inventors just go to investors without protection and they just copy it and file it on their name, because India Patent Office, they accept only first to come first basis only. Then is patent office does not grant patents rights easily for software inventions. It's not like that. If you have properly explained the steps and it is not algorithm per se, of course you can get patent granted. Now even many inventors, they have got grant on the blockchain, on QR codes, many different types of patent applications are there. So if next myth is I can do minor changes in my algorithm and I will then enjoy monopoly rights forever. I like told you. Now these changes, so suppose after 20 years are over and an inventor thinks that, okay, I will do some changes and some product, now there is some changes in the product, so then I will file another patent and I will get the monopoly rights. It's not like that. Your changes, they have to not to be obvious, means कि छोटा मोटा सा change कर दिया and then you are getting something which is like obviously it should be there. For example, I have attached a fan to my pen so that I feel air, coldness when I'm writing. So this is just an addition and it is not giving anything. Obviously, fan will give air only. So then it cannot be granted patent right. Patent application is like a research paper. Now it's very, very important, especially to the researchers. So it's not like a research paper. Research paper is you are just disclosing your research, you are getting published, which is getting acknowledgement by the journal. But a patent application is an application which is being applied to get legal rights, legal protection on your idea. It's not a research paper, please. If anybody has doubt on this point, they can ask me, but it's not a research paper. For the students especially, what can be the career opportunities in IPR? You can go to patent analyst. In this, there are many projects like searching or some landscapes are there. So in which we actually require patent analyst who can analyze the data, the patents. For this, you have to be technically sound and you should have good English understanding skills. Patent drafter or prosecution, this is we have to have a very good command over English, and this is and technical command also. So in which we prepare the patent applications, for which we have to be technically and legally sound. Patent trademark agent, this is if you clear a patent agent exam and then you become an agent, you can file the patent application on behalf of your inventors and applicants. Patent trademark lawyer is a lawyer who does LLB. So for agent, you can go for this exam after your graduation in science. But for lawyer, LLB, candidates, they can also come for patent lawyer, but they cannot file the patent application. They can only go for prosecution level. For example, for defending the cases in High Court. In-house counsel like R&D, like for example Microsoft, they have their own in-house IPR department, so they have counsels who handle their IPRs. Patent broker is a very famous term in US, but in India it is not that much famous, so this is going to be a good career. In this patent broker, just like a property brokers are there, you have to purchase a property, you will go to a broker and broker will help you to, he will show that these are the properties and you can just select which one is suitable to you. Similarly, there are patents which are being granted and now they have to be commercialized. So, either they can go for licensing or you can just sell those patents. So for that you will go to the patent brokers. So this also can be good career. Then patent portfolio owner or inventor. Of course, some people, they just like to be inventor. I have my many clients as being individual inventors and they have a target of filing 100 patents, So there can be, many career opportunities in IPR, and it's going to be a booming industry for students especially. So I would just conclude that each one of us is a born inventor. Do not think that only if you will do master's degree or PhD degree, then only you will think of an idea, or we will not think researchers or it's a scientist's responsibility, they will come up with a solution. It's not like that. Each one of us is a born inventor. It's about awakening ourselves. It's about being conscious of our surroundings, realizing what is the problem. Now, when we stopped, getting products from China, of course, in many Indians, they come up and they came up with so many brilliant inventions and solutions to replace those Chinese products. So it's about, making ourselves conscious of our surroundings and to know that if you can solve the problem. And you know that our mind thinks 60,000 to 80,000 thoughts per day. which is a mixture of positive and negative. Some junk thoughts are also there. And out of this, if you will still pay attention to these thoughts, you actually find out solution every day, but we don't pay attention to. Some inventors, they keep on writing in their diary that, oh, they have come up with a problem today, this, they have to think, and after some days, they will come up with a solution for that particular problem. And so this is our services, UniPatrde. Actually, this is why we gave this name UniPatrde. Uni means Vishnu, single, and PA means patent, TR means trademark, DE means design. So this is UniPatrde. And we give all the services in India and overseas in all the countries. Thank you. I hope you enjoyed the session and I was able to clarify your doubts or problems. If anybody is having any questions, please feel free to ask.
Yeah, definitely, ma'am. Thank you very much. It was very informative session. And before we conclude the session, I would like to ask from the students if they have something to ask. Otherwise, I have one query in my mind. First, I'll prefer students to ask something if there is any query from their side. Well, meanwhile, I'm just coming up with my query. In fact, it is the query of my kids, in fact, because they are fond of, creating the videos and all. So now the question arises, if my daughter is, fond of dancing. So whenever she tries to record a dance with a very popular song, my son used to object. He mentioned, no, वो जिसका copyright है वो strike मार देगा. So what is the exactly, what is the exact picture related to that copyright of the songs and all, and can she put her dance video with the popular songs or not?
Okay. Yes, actually, this is a very common question, and it's actually a very good question because these days we are uploading so many videos on YouTube and especially dance videos. Now, just try to understand that the song, it is already copyright by somebody else. So if you are using his property and you know that YouTube also generates revenue if there is certain target achieved. So now when it comes to the revenue, of course, the owner of that song will have the objection that the revenue has to be shared with him. So that's why it's always being objected, and also he can put a case on you that you have infringed his property. So most likely, preferably, you should have taken permission from the owner of that song and then you can upload your video.
Right, ma'am. Thank you. And there is another query, and in fact, this is my own one. Recently, I was in a process of getting some patent filed, and one I could with somebody, and one is still in the process. Meanwhile, I came up with various aspects of this. I mean, some people are involved into it who are, trying to drain a lot of money out of the persons, those who are trying to. So one such proposal was with me related to the Australian patent.
Okay.
I came to know there is some, gameplay with terminology, if you are aware of. Like filing and publishing and then getting the granted status afterward in the India. Probably in Australia, it is like when we file it, we immediately get the granted status, and afterward, after examination, we get the status of allotted or approved kind of thing. So is it true, or it is just a story that I came across?
Okay. No, actually, there is in some countries, not in India, but in countries like Australia, there are two types of patents. One is innovation utility patent, and another one is the standard innovation patent. Now, standard innovation patent is just like the patent procedure we have in India. wherein you have to get your application filed, published, examined, then only you will get the acceptance certificate that your application is being granted patent rights. But for innovation utility, they actually came up with an idea with a low, price kind of low cost model for some startups, for individual inventors, in which they say that you file your patent application, we will publish your patent application based upon some legal requirements. So there will be some official requirements by the Australian Patent Office. They will just examine on the basis of that, but they will not do any technical examination. Means they will not check the novelty, they will not check the inventive step, they will not check the obviousness and the industrial applicability. So your application will get published on the basis of that, and you will get a certificate that, okay, your application is now published. Now you have 8 years of time to get your application examined. Suppose you have an idea, an invention. Now you have filed through innovation utility. You have got your application published. You have received the grant certificate also. And suppose you launch your product in Australia and somebody copies your product. Now you will not be able to enforce your patent rights. Why? Because you did not got your application examined. So technically, your application was not being examined, like novelty and all those factors. So for that, you have to get it examined. Then only you will be able to stop that person to infringe your patent. So this is the difference between the two. So this was basically a grace period for examination. Like in India, there is like 4 years time within you have to file the examination request. So in Australia, they have basically extended that time for the examination through this.
Right, ma'am. Thank you very much. If there is any more queries, I'll take up for forwarding it to the Neha ma'am. Otherwise, I would like to conclude. Is
Sure,
there anybody? No, so it looks like
I want to say one thing. Our DG sir is also in the meeting, so we want to welcome our Director General sir, Pranveer Singh sir, in the meeting.
Thank you, sir. Thank you. I am here.
So I also welcome our Director General, Dr. Pranveer Singh, to the event. Sir has probably just joined us, and we are winding up the session. And
I'm sorry. I'm sorry that I could not manage myself.
But it was really a very wonderful session, sir. Even I tried to involve the faculty members along with the students of the second year. Because of the examination, we could not manage the other students to join this. But it is such a wonderful event that I'll request Mr. Sir to organize it again, and to bring more students into the meeting and to get the benefit. So, formally, I would like to conclude the event. Thank you, Anuranjan sir, our Dean Research and Development, to bring such experts on the panel to enlighten us. Thank you, Director General sir, to support us for such kind of events all the time. And a lot of thanks to Neha ma'am to spare the time and give such wonderful insight of the patent. Thank you, students. Thank you, faculty members. See you next time. Thank you all.
Thank you so much, sir.
Thank you, Neha ma'am, and we will try to make you here physically in the campus, so we can interact with you, and we can learn more about that patent and other things.
Yes, sure, sir. It would be our pleasure to share the knowledge with your students, with the faculty, and everyone in the institute. And it's very, very important to make our students and faculty, aware of their intellectual property rights, because in India, India is always known with the word jugaad. So we all have jugaad minds, but we are not aware of these jugaad minds. So we come up with solution to every problem, And what the foreign countries, they are just trying to protect those innovations. So it's very, very important to make all of us, aware. So it's not like that if I'm into the IPR, so I should not think for a solution. So I also keep on inventing, and I also encourage the school students also, because there is no age bar. So everybody should at least protect those inventions. So then only we can actually get acknowledgement for those protections. So it was really a great platform, and if any student has any questions, so they can directly send email to me. So I have already shared neha.goyal@unipatrde.com.
Yes,
Yes.
ma'am. I'm little becoming more greedy that to, if possible, and I urge that the Professor Anuranjan and Professor Rajdev, if we can have that kind of the center of that the means facilitating that the IPR kind of things.
Right.
So
Yes, we
I
can
I have
start with, sir.
discussed with the madam also. Very soon, with the help of IIC cell, we are developing an IPR cell, and madam is a part of that IPR cell also.
That will
That
be the
we can
better.
facilitate the students as well as the faculty members who wish to go for the IPR.
Yes, at the same time, not only formulation, the visibility of that IPR cell should be there, vibrant across that the campus.
Right, sir.
Then
Yes,
definitely we can get something and see that we our young minds they can have that very different kind of the ideas, and
yes,
that may have the values also. That can help that our humankind. So that possibly can go for that IPR kind of things. This is my because I've been in the IIT, so they are the IPR cell, and every time they used to weekly or monthly used to have that some kind of the program. So we used to have that, and the vibrations give that the some kind of outcome, good outcome. Am I right?
Right, sir.
Worthy outcome. That will be the better, Sir Anuranjan sir, and make it that the at the because your the cell is that little one side of the campus. Make it the bring it here that main campus, that the nearby reception or kind of things. Then that
yes, sir.
visibility will be
Definitely,
more.
I will demand the space from you. If definitely it will be provided,
Yeah,
we'll shift
see,
into that
I'm
place.
not saying that the labs may be there, but the one cell or one kind of the office to be nearby that our main offices, that will be the better.
Yes,
Thank you, ma'am. Thank you, Neha, ma'am.
Thank you, sir.
I'm sorry that I could not manage to listen you.
So we can have more sessions, no issues.
Thank you.
and
So nice.
Yes.
we will
Thank you
upload
once
this
again. Thank you
the
all. And
IIC
next time we'll,
Ministry of Education side also. This video is uploaded. So any
Yeah,
want to see, they can see the video from the Ministry of Education side also.
yeah. Another program is also going on. I was there, so again I have to rejoin that. Okay. Thank you once and all.
Thank you
Thank you,
very
sir.
much, sir.
thank you, sir. Thank you, ma'am. Thank you. Thank you. And see you once again.
Yeah, sure.